Hi everyone, welcome. I have a PowerPoint and I'm just going to walk through the decision that was announced last Thursday that we were all very, very excited about. And, I will admit that we were all pretty surprised about it. I'll speak for myself. I was anticipating the worst and so happy to finally get a piece of good news in this moment. So if we go to the next slide, today, in the next 25 minutes or so, I'm going to cover a few things. I'm going to walk through the decision and really talk about, pull out some quotes to share with you, talk about how they came to the decision that they did to rescind the termination of DACA. Talk a little bit about what this means, both for current DACA recipients and potential new applicants. And then, as Jen just mentioned, I'll once again share legal supports for those of you who need more information or access to a lawyer. And then we won't have questions live, but feel free to pop stuff in the chat and we can also try to get back to you. So next slide. So the decision, next slide. So last Thursday, Chief Justice John Roberts, seen here on the right with President Trump, was appointed by George W. Bush in the early 2000s. He's the Chief Justice of the Supreme Court, and he actually wrote the opinion in this DACA decision. It was a 5-4 opinion, and so Chief Justice John Roberts joined the 4 other, quote unquote, liberal members of the court. And in order to write this opinion that DACA would be upheld, that the way that the administration had terminated the DACA program was unlawful. So we can go to the next slide. And so in his opinion, Chief Justice John Roberts so ordered that the memo written by Acting Secretary Elaine Duke of Homeland Security in September of 2017 was rescinded. And so the 2012 memo that originally created the DACA program under President Obama was reinstated. So let's walk through the decision a little bit. So next slide, yes. Before we do that, I just want to do a little bit of provide a few definitions because these are words that come up a lot over the course of this opinion from Chief Justice John Roberts. So the first one is forbearance, and that's just another way to say protection from deportation. Basically, the deferred action for childhood arrivals. It is what protects people. It's what prevents people from being deported if they are under this deferred action program. Reliance is the other side of deferred action for childhood arrivals. So we think about DACA, you can think about it in 2 parts. One is the protection component, which says, we, the government, will not deport you while you are under the protection of this program. And then the other side is the benefits component. And those are, everything from the most basic of the work permit, which is issued to DACA recipients, to all of the other ways that DACA recipients have been able to use their DACA status to gain other benefits. So, for example, being able to access in-state tuition in some states around the country, like here in New York, whether it's to be able to get a driver's license or apply for health insurance or any number of things that with the DACA status that now people have access to. So those are two big concepts: forbearance, which is the protection component of DACA, and reliance, which can generally be thought of as the benefits component of DACA. And then there's something overarching, which is incredibly important, called the Administrative Procedure Act, or the APA. And the APA was passed decades ago, and it basically governs the way that administrative or federal government agencies, like the Department of Homeland Security as a perfect example, the kinds of ways and policies they must follow when making decisions. And basically the APA, as it says here, that states that a court shall hold unlawful and set aside agency action found to be arbitrary, capricious, an abuse of discretion, or otherwise not in accordance with law. And so that just means that the court has the authority to determine if an agency acts completely unreasonably, doesn't take into account multiple factors that might govern how a decision will to repeal or enact policy will impact Americans. And so really the crux of the argument in front of the Supreme Court was around whether or not the Department of Homeland Security violated the Administrative Procedures Act. So next slide. So this is a quote from John Roberts from his opinion. So we do not decide whether DACA or its rescission are sound policies. The wisdom of those decisions is none of our concern. We address only whether the agency complied with the procedural requirement that it provide a reasoned explanation for its action. So this is exactly what I was just talking about. Basically, what John Roberts is saying here is that what the issue in front of the Supreme Court and in front of the courts, the lower courts that had already made decisions on the issue before it got to the Supreme Court, was not whether or not DACA or the repeal of DACA was a good policy, or even whether DACA itself is a legal program. What the Supreme Court was considering was whether or not the way that the Department of Homeland Security went about terminating the DACA program violated law, violated the Administrative Procedures Act, the APA. And so he ends his quote by saying, here, the agency, which is Department of Homeland Security, failed to consider the conspicuous issues of whether to retain forbearance and what, if anything, to do about the hardship to DACA recipients. And so what John Roberts is saying here is that in his estimation and in the estimation of a majority of the Supreme Court, the Department of Homeland Security did not consider whether they should continue the protection from deportation of DACA recipients, or what hardship would befall upon current DACA recipients by terminating the program. And I know that many of us already knew that. We knew that this Department of Homeland Security, DHS, under President Trump, is cruel and incompetent and doesn't care about immigrant families. They're pursuing a radical anti-immigrant white supremacist agenda. And in some ways, John Roberts, in a small way, is acknowledging that by basically saying that the Department of Homeland Security didn't take whether they had the ability to continue protecting DACA recipients from deportation, or the hardship that would befall on DACA recipients when making the decision to terminate DACA. Next slide. And so really, this is the crux of the decision. This is the meat of it, that dual failure to consider either of those things raises doubts about whether the agency, so that's Department of Homeland Security, appreciated the scope of its discretion or exercised that discretion in a reasonable manner. So what John Roberts is saying is that he has determined that the agency, that DHS, failed to take into account either of those two things. And so that calls into question whether or not that Department of Homeland Security used their discretion, used their decision-making power to terminate DACA in a reasonable manner. And so he goes on to say, the appropriate recourse is therefore to remand to DHS so that it may consider the problem anew. And so that means that, in this opinion, the Chief Justice is basically vacating or getting rid of the September 5th, 2017 memo that was written by acting DHS Secretary Elaine Duke terminating the program. And by vacating that memo or getting rid of it, saying that it violated the law, it violated the Administrative Procedures Act, that the original memo went back into effect. And that original memo was the one that was written by then Department of Homeland Secretary Janet Napolitano under President Obama, creating the DACA program in the first place. And that was from June 15th, 2012. So now the Supreme Court under Chief Justice John Roberts is saying that that is the memo that is now in effect. Next slide. And that's huge, right? that's the win. So let's get into a little bit about how the Chief Justice came to this decision. So this is what he wrote. The dispute before the court is not whether DHS may rescind DACA. All parties agree that it may. So in this, I just want to point out that there were multiple court cases filed across the country in the immediate aftermath of DACA being terminated back in September of 2017. There was one in California, there was one in DC, there was one in New York. And in all three of these court cases, the federal judges ruled in our favor, in the favor of DACA recipients. The one in California was also brought by the University of California's higher education system, saying that it would impact their students. As Yasmin mentioned at the top of the call, many incredibly brave DACA recipients, including from Make the Road New York, here in New York, came forward and served as plaintiffs that, they obviously were going to be personally impacted by the termination of DACA. In all three of those court cases, the separate federal judges ruled in similar fashions and basically issued nationwide injunctions. So they said, this is our ruling. We're ruling that the administration violated the APA. And because they violated the APA, we're issuing a ruling requiring DACA renewals to continue. Because we think we're going to win, we think that this is the right decision. Even as this case is being appealed up to the Supreme Court, we want DACA renewals to continue. And so that's why for the past 2 years or so, DACA renewals have continued because lower federal courts across the country have ordered them to. In the case that the Supreme Court ultimately decided on was the case that was brought in Washington, D.C., and one of the lead plaintiffs was the NAACP, but also DACA recipients. And in this first sentence, what the Chief Justice is saying is that, no one, not the plaintiffs, so the DACA recipients and the NAACP, was arguing that the Department of Homeland Security didn't have the authority to terminate the DACA program. Instead, what they were saying is that they didn't do it the right way and that they didn't do it based off of current law. They didn't follow the processes that they were supposed to follow. So that's what he says here. He says the dispute is instead primarily about the procedure the agency followed in doing so. Because the DACA program is more than a non-enforcement policy, its rescission is subject to review under the APA, the Administrative Procedures Act. And because it was reviewable under the APA, total rescission was arbitrary and capricious. So in order to understand why this is important, it's important to know kind of some history around these programs. In the waning years of the Obama presidency, after DACA had been in place for 2 years, President Obama announced something called DAPA, which would have been similar to the DACA program, but would have provided protection from deportation and access to work permits for the parents of U.S. citizen and LPR children. It would have been a much larger scale program that would have benefited many more people than even DACA did. Before that program was able to be implemented, the Texas Attorney General, along with a number of other conservative states' attorneys general, filed a lawsuit in the Fifth Circuit down in Texas, alleging that the DAPA program itself was illegal, was unconstitutional. And unfortunately, that case went in front of one of the most conservative anti-immigrant judges in the country, in the Fifth Circuit. And that judge ruled that because the DAPA program would require states like Texas to give benefits to DAPA recipients, things like driver's licenses or access to in-state tuition or healthcare or any number of other alleged benefits, that the Department of Homeland Security did not have the authority to do this kind of wide-scale deferred action program because of the benefits involved, that it would cost. Texas alleged that it would cost them money. I mean, we all know that that's entirely untrue. But this judge unfortunately sided with the state of Texas. That case went up to the Fifth Circuit Court of Appeals, where they upheld that judge's decision. And then it did make its way to the Supreme Court. And at the time, the Supreme Court was only had 8 members on the court. There was one empty position, and the Supreme Court tied 4-4 in that case. And so the lower court's ruling was upheld, and DAPA was never able to go into effect. What the government has been arguing in the DACA case is that because in that case, the Fifth Circuit found that the DAPA program itself was illegal, because of this, because of the benefits that it would confer upon anyone who was eligible, applied, and was granted the status, that they did not need, that it wasn't subject to the APA, to the Administrative Procedures Act, because it was an immigration benefit. And what John Roberts is saying here is that DACA is not just a non-enforcement policy, but it is a much fuller program, and that the agency, it is not just about immigration law. And because of this, because of all of these different ways that DACA has been used and put into effect, that any decision about DACA did need to follow the APA. And so their decision to terminate DACA in the way that they did it violated the APA. Next slide. So let's just do a little flashback to the day that the DACA termination was announced. So I'm sure many of you remember it vividly, September 5th, 2017. And on the left-hand side of your screen, you will see then Attorney General Jeff Sessions, who led the Department of Justice at the time. He used to be a senator from Alabama, notoriously anti-immigrant, introduced many pieces of anti-immigrant legislation, and a friend of Donald Trump, or used to be a friend of Donald Trump. And it was actually Jeff Sessions who made the announcement and gave the speech outlining why and how DACA would be terminated. But the truth is that the DACA program is not a program of the Department of Justice, where Jeff Sessions was the leader. It's a program of the Department of Homeland Security, DHS. And Jeff Sessions was not the person that was going to write the memo terminating the DACA program. It was actually acting Secretary of DHS, Elaine Duke. So in the months leading up to this DACA termination decision on September 5th, there had been a lot of speculation and news reports about when and how the Trump administration was going to terminate the DACA program. And that was because that same Texas Attorney General who brought the lawsuit against DAPA had gotten a bunch of his conservative anti-immigrant attorneys general together again. And they had sent a letter to the Trump administration, basically a ransom note. And they said, if you don't terminate the DACA program before the end of the summer, we will file a lawsuit, just like we did with DAPA, in order to get the courts to end the program. And so all summer, we at the NYIC and people, across the state, across the country, had been anxiously wondering what was going to happen. And so I can't say that we were completely surprised on September 5th when this decision came out. But what's interesting to know is that we were wondering why it took so long, right? We all know that Trump is an anti-immigrant white supremacist who had made this promise to end the DACA program on the campaign trail. And we were wondering why it took so long. Well, the day after, on September 6th, the New York Times article ran that basically talked about the fact that the Trump administration, including Stephen Miller, who's his immigration policy, anti-immigrant, policy advisor in the White House, Jeff Sessions, other anti-immigrant folks in his administration had been pressuring the Department of Homeland Security to issue the memo. And allegedly, they had come up with all kinds of policy reasons that they claimed justified ending the program. things that we know are blatantly untrue, things like they take jobs from from Americans, that they're a drain on our resources, that they cost more than they make, all of these things. But there was a problem. Elaine Duke, who was the acting secretary, who had been at DHS for a little while, didn't want to issue the memo. She didn't want her name connected with stripping protections from almost 1 million young people in the United States. And she didn't think it was good policy. And so they pushed her and they pushed her and they pushed her. And so finally, she didn't resign. She relented. And so if you go to the next slide. So on September 5th, she issued a 1-page memo. And I don't know if Elaine Duke, then acting secretary, did this on purpose. That's her with the heart around her face. I don't know if she did this on purpose, but her 1-page memo, and if you can see, it might be a little small, what I've underlined, basically says that the only reason that the Department of Homeland Security was ending the DACA program was because it was illegal. That's it. She didn't include any of the other policy reasons that the Trump administration had been talking about, either in closed rooms or that Jeff Sessions mentioned when he gave a speech. She wrote this 1-page memo and she said, "It breaks my heart to do this, but the DACA program is illegal. And so DHS has no other choice than to terminate the program." And ultimately, this is what allowed Chief Justice John Roberts to save the program. And so, just want to give a special shout out to Elaine Duke, wherever she is. Thank you. I don't know if she did this on purpose, but I like to think that she did. Next slide. So let's talk about how it made a difference. So John Roberts says, even if it is illegal for DHS to extend work authorization and other benefits to DACA recipients, and so this is referring to Elaine Duke's memo, basically saying that conclusion supported only disallowing benefits. It did not cast doubt on the legality or of forbearance, so the legality of deferred action or protection from deportation, or upon DHS's original reasons for extending forbearance to childhood arrivals. So the original reason that was included in Secretary Napolitano's memo about why DACA was created. Thus, given DHS's earlier judgment from the 2012 memo creating DACA, that forbearance is especially justified for productive young people who are brought here as children and know only this country as home, the DACA memorandum could not be rescinded in full without any consideration whatsoever of a forbearance-only policy. So what John Roberts is saying here is what I was explaining before. Basically, that even if Elaine Duke believed that the DACA program that conferred benefits, that gave work permits to DACA recipients was illegal, that she should have taken into consideration whether it would have been possible to have a DACA program that didn't give work permits, but only protected people from deportation. And she did not take that into account, and she did not consider that as a possibility when making her decision to terminate DACA. Next slide. The consequences of the rescission, respondents emphasize, would radiate outward to DACA recipients' families, including their 200,000 U.S. citizen children, to the schools where DACA recipients study and teach, and to the employers who have invested time and money in training them. Even if DHS ultimately concludes that the reliance interests rank as serious, they are but one factor to consider. DHS may determine in the particular context before it that other interests and policy concerns outweigh any reliance interests. Making that difficult decision was the agency's job, but the agency failed to do it. So here what John Roberts is saying is that, so we had forbearance, so you could have just protected them from deportation. But also, you did need to take into consideration the significant hardships that would befall upon DACA recipients and their U.S. citizen children, the schools where they study and teach, and the employers who have invested time and money into their employees. You have to have at least considered that hardship. And it doesn't mean that that hardship had to outweigh the decision to terminate DACA if there were significant reasons on the other side to terminate the program. He's saying that that's fine, that that's your choice, but that you didn't even consider that. You didn't even make that difficult choice. You just completely ignored it. And so, that means that you completely abdicated your responsibility under the Administrative Procedures Act. Next slide. And he writes, but neither the government nor the lead dissent cites any legal authority establishing that such features automatically preclude reliance interests, and we are not aware of any. These disclaimers are surely pertinent in considering the strength of any reliance interests, but that consideration must be undertaken by the agency in the first instance, subject to normal APA review. There was no such consideration in the Duke Memorandum. So just repeating, what I just explained, that the Duke Memorandum does not include any of this kind of reasoning about how or why it would be in the government's interest or in DHS's interest or the American people's interest to terminate DACA. And what Justice John Roberts is saying is that it's not up to me as the Supreme Court to decide whether or not the way you weighed those options or benefits was the right way, but it is for me to say whether or not you weighed them at all, and you clearly didn't. One thing I do want to note is that Elaine Duke was quickly forced out as acting secretary later in 2017, and the new then secretary was Kirstjen Nielsen, who also oversaw family separation in 2018. So a real winner. About 9 months after the DACA program was terminated in September of 2017, Kirstjen Nielsen drafted a memo basically outlining all of the additional policy reasons that the administration would have to terminate the DACA program, all of the things that I don't agree with or believe in, but that I mentioned before, the impact on the economy, the impact on jobs, a drain on society, et cetera, et cetera. And the government tried to say, hey, look, we did take these into consideration. These are all the reasons why we think, terminating the DACA program is the right move. And John Roberts, pretty forcefully says, you can't issue a memo 9 months after you made the decision, justifying the decision you made 9 months ago, and didn't even take that memo into account. And so just another way in which Elaine Duke really saved us, and Kirstjen Nielsen was a horrible secretary of DHS. Next slide. So what does all of this mean? So that's the opinion in a nutshell. Basically, John Roberts said, DHS, you didn't do your job, reverts back to the 2012 DACA memo. So next slide. For DACA renewals, they will continue on exactly as before. So as I mentioned, 3 lower courts had found exactly what the Supreme Court found, that the way the Trump administration terminated the program violated the APA. And because they found that, they immediately issued these nationwide injunctions demanding that USCIS continue accepting DACA renewals, which has been happening. And so that will continue now to happen, not a nationwide injunction, now just as the law of the land. The Supreme Court has spoken. And so renewals will continue as exactly as before. Next slide. Where it gets more tricky is, what does this mean for new applicants? So that broadly falls into 2 categories. People who have turned 15 since September 5th, 2017, because generally speaking, you have to be 15 in order to proactively apply for DACA. And there definitely are individuals who have been here since 2007, who came into the U.S. before the age of 16, who meet all of the other eligibility requirements, but were too young to apply for DACA before it was terminated on September 5th, 2017, who could now apply potentially. And then, of course, people who who are under the age of 31 and for whatever reason never applied, but are eligible. Now, It's our belief, and I think the general belief is that USCIS should begin accepting new applications. That what John Roberts' opinion means is that the DACA program reverts back to that original 2012 memo establishing the program written by Secretary Napolitano. We are still waiting on guidance on a new memo from USCIS that explains how they're interpreting the decision. And this is especially true for advanced parole. So the 2012 DACA memo outlined that DACA recipients would be able to apply for and receive advanced parole. That was also terminated, that ability, in the September 5th, 2017 rescission memo. We encourage anyone who would be a new initial applicant to DACA for the DACA program, or anyone who is considering potentially applying for advanced parole, to access legal services first, talk to a lawyer. And I'm going to share some resources with you in a couple of minutes of who you can reach out to before submitting anything to the Department of Homeland Security. There's a lot we don't know yet. And it's really important that before anyone turns over information to this Department of Homeland Security run by this administration, that they really understand all of the implications. And so NYIC is going to be monitoring this along with, I know, our friends at the New York City Mayor's Office of Immigrant Affairs and others, and we'll share more information as soon as we have it. Next slide. But we all know that the only real solution is a permanent solution. And so that's why we're calling on the Senate to immediately take up HR 6, which is the Dream and Promise Act, which would put DACA recipients and DACA eligible folks and TPS recipients and eligible folks on a road to citizenship and permanent solution here in the United States. Next slide. So as I mentioned, for folks that have questions about your own status, whether it's about a DACA renewal or potential new application or advanced parole, we really encourage you to reach out. If you live here in New York City, you can reach out to Action NYC, the number's on the screen, or you can call 311 and say Action NYC. Outside of New York City, you should call the Office of New Americans, ONA hotline, and the number is on the screen here.